You just spent $4,000 on wedding photography. You have the USB drive, you have the online gallery, you have the leather-bound album on your coffee table. But if you didn't sign a separate legal document specifically transferring rights, your rights to those images are sharply limited. You do not own the copyright to a single one of them. The photographer does. Under United States federal law, paying for the service doesn't buy you the picture. It buys you permission to look at it. The confusion is everywhere. Walk into any wedding forum and you'll find the same assumption. I paid for the photos, so they're mine. Couples budget $5,000, $6,000, sometimes $10,000 for coverage of their celebration, and they naturally believe that fee purchases the images themselves.
It doesn't. What it purchases is a service contract, physical deliverables, and a limited license to use those files for personal display. The intangible intellectual property, the federal copyright, remains with the person who clicked the shutter.
The legal system doesn't care who paid the invoice. It cares who created the work. That distinction sits at the heart of nearly every dispute between couples and photography studios, and most people don't discover it until they try to do something the contract did not allow. The rule comes from the Copyright Act of 1976. Under Section 102, copyright protection applies automatically to original works fixed in a tangible medium. The instant light hits the sensor and the file is written, the image is protected. Section 201 makes it explicit. Copyright vests initially in the author. In photography, federal courts have been clear for over a century that the author is the person operating the camera and exercising creative control. The Supreme Court settled this in 1884, when a lithographic company copied a studio portrait of Oscar Wilde and argued photographs were just mechanical outputs with no human authorship. The court rejected that claim. It held that the photographer, who poses the subject, selects the backdrop, controls the light, and chooses the moment, is the author. Modern courts apply that same principle to candid event photography. The exposure settings, the lens choice, the composition, the timing, the post-production color grading, all of it qualifies as original creative expression. The couple standing in front of the camera is not the author. The person paying the invoice is not the author. The photographer is. Some couples assume the arrangement must be a work made for hire. After all, they commissioned the work. They directed the schedule. They paid for the result. What most people don't realize is that federal law disagrees. Under Section 101, work made for hire applies in exactly two narrow situations. First, when an employee creates the work within the scope of actual employment. Think of a staff photographer on the payroll of a magazine. A wedding photographer is an independent contractor, not a W-2 employee. So this prong fails immediately. Second, when the work is specially commissioned and falls into one of 9 statutory categories: a contribution to a collective work, part of a motion picture, a translation, a supplementary work, a compilation, an instructional text, a test, answer material for a test, or an atlas. Standalone wedding photography is not on that list. It is not a translation. It is not an atlas. Federal courts interpret those 9 categories strictly. That means inserting the phrase "work made for hire" into a standard wedding contract doesn't transfer copyright. It creates a legal void. The title stays with the photographer unless the couple executes a formal assignment under Section 204, which requires a written instrument signed by the rights holder. Without that signed document, the photographer retains full federal copyright ownership, regardless of what the invoice says. American couples now spend an average of $30,000 on their weddings, and the copyright assignment clause typically receives less attention than the dessert menu. When you sign a standard wedding photography agreement, you are almost certainly receiving a non-exclusive personal use license, sometimes called a print release. This is not ownership. It is permission. Under this license, you can make physical prints for your home. share high-resolution files on personal social media, and send images to family members. What you cannot do is grant those same rights to anyone else. You cannot hand the files to your wedding venue for their commercial advertising campaign. You cannot let the florist post them on a monetized Instagram account. You cannot sell the images to a stock agency. You cannot apply heavy filters that alter the photographer's creative choices and claim the result is your own. Each of those acts crosses the boundary from personal use into commercial exploitation or derivative creation, and each requires the copyright holder's separate written permission. The photographer retains the exclusive rights to reproduce the work, distribute copies to the public, display it publicly, and prepare derivative works. Your $5,000 package bought you access, not authority. But the part almost no one knows is still coming. The real legal danger isn't what you can or can't post online. It's what happens when the studio takes your money and vanishes before you ever see your photos. In 2015, a couple in Pennsylvania discovered their wedding photographer using private images in commercial marketing brochures, despite a contract that explicitly prohibited any display beyond personal use. The couple had even registered the copyrights themselves. They sued for infringement, misappropriation of likeness, and right of publicity violations. The case, Hines versus Pros Entertainment Services, established a critical boundary. Even when a photographer holds the copyright, publishing recognizable client images for commercial advertising without a signed model release violates state right of publicity statutes. The photographer's copyright does not override the subject's right to control the commercial use of their own face. Then there is the 2017 Texas dispute, Polito versus Moldovan. A photographer sued a couple for defamation after the couple launched a viral social media campaign claiming the studio was holding their pictures hostage over a standard album cover fee. The contract explicitly required the fee. The jury awarded the photographer over $1 million in damages. The question of whether justice was served depends entirely on which side of the camera you were standing. Both cases sit on the same foundation. One party misunderstood what they had purchased, and the misunderstanding turned into a federal lawsuit. State law adds another layer. In February 2024, the North Carolina Attorney General filed enforcement proceedings against Holly Christina Photography after 217 consumer complaints representing roughly $1 million in lost funds. The studio had collected deposits, delivered brief sneak peeks, then vanished without providing full galleries or refunds. The state sought restitution and emergency injunctions compelling the photographer to surrender unedited raw files. That action underscores a vital point. While copyright defaults to the photographer, consumer protection statutes can compel delivery of the physical media when a studio breaches its contract or dissolves entirely. The copyright may still technically belong to the photographer, but the files themselves can be ordered transferred to the clients under state enforcement. The same principle applies to so-called non-refundable retainers. A wedding contract can label an upfront fee non-refundable, but state courts treat that language as a liquidated damages clause, not an automatic forfeiture. The amount must reflect a reasonable estimate of the actual economic harm the studio suffers by losing the date. If the photographer breaches by double booking or failing to appear, the clause becomes void entirely, and the client is entitled to a full refund. In states like New York and California, the studio also has a duty to mitigate. If they rebook your date at equal value, keeping your full deposit may constitute unjust enrichment. So here is the legal reality. The photographer owns the copyright from the instant the shutter closes. Paying the invoice does not change that. Calling the arrangement work made for hire does not change that unless the narrow statutory requirements are met. The only mechanism that transfers ownership is a signed written assignment under federal law. Without it, you hold a license, not a title. The license lets you print for your walls and share with your friends. It does not let you sell, sublicense, or commercially exploit the images. And if you want to stop the photographer from using your face in their advertisements, you need a separate negotiation over model release rights, because copyright and publicity are not the same thing. One governs the image, the other governs your likeness. If you are planning a wedding or know someone who is, this could happen to you. There are 4 contract provisions worth negotiating before anyone signs. First, demand an explicit, non-exclusive, perpetual license to download, print, and display high-resolution files for personal use, without per-print fees or lab approval. Second, request a vendor sharing clause that permits you to provide images to your florist, planner, and venue for non-monetized portfolio display and social media tagging. Most photographers accommodate this if asked up front. Third, modify the model release. If you want privacy, strike the blanket promotional provision and replace it with prior written approval for any public display, or limit usage to the photographer's primary website with no paid advertising. Fourth, and most critically, insert an emergency clause. If the studio dissolves, fails to deliver, or breaches the agreement, the contract should require immediate surrender of all unedited raw files to you. This does not transfer copyright automatically, but it preserves your visual record when the business collapses. Finally, define your deliverables with numbers, not adjectives. Specify a minimum count of fully edited, high-resolution files. Specify a firm delivery deadline. Specify the file format and the delivery method. The phrase, "all the best photos," means nothing in court. 500 edited JPEGs delivered within 8 weeks means everything. The next time you see a wedding photographer's portfolio filled with stunning ceremonies and emotional first looks, remember that every single one of those images is legally theirs until a signed document says otherwise. The couple in the frame paid for the moment. They did not automatically pay for the rights. If you found this useful, subscribe before you need it, because the contract you signed 6 months before the wedding is the one that determines what you can do with the photos 40 years later. Tomorrow, we're examining why depositing smaller amounts into your bank account, something most people do without a second thought, can trigger a federal seizure of the entire account without a single criminal charge. The government doesn't need to prove you did anything wrong. They just need to notice the pattern. You'll want to see that one.